Welcome to the SpicyIP Podcast, the Summer School edition. Today, we have with us Mr. Murali Neelakantan. Welcome, sir.
Thank you.
Sir is the principal lawyer at Amicus. He has extensive experience in working in the pharmaceutical industry, including being the general counsel of Cipla. He is also a prolific writer who's written various op-eds on intellectual property rights and healthcare. We have a couple of questions for you today, sir. Could you take us through your journey of being in the pharmaceutical industry and what inspired you to come in here?
I think it happened quite by chance.
Right.
I'd been a lawyer for many years in the UK and in India. And in about early 2013, Cipla became a client. And I started spending a lot of time in the Cipla offices, advising the senior management. And as time passed, by about September, they decided that I was spending more time there than in my own office in the law firm. So they suggested that I should join the company. At that time, it wasn't very clear what role I would play there. So they created a new post called the Global General Counsel in the CEO's office. So for me, the excitement was it's a new role. I had never done something like this. I don't think many lawyers in India had done it before. So it was just the excitement of doing something different. Also, I'd been a lawyer for a very long time. There's only that many commercial transactions that will excite anyone after a period of time.
Right.
So it seemed like a good thing to do. And I liked the idea of being involved in the business. I'd always been that kind of a lawyer. So that's how it happened that in October 2013, I moved to Cipla and didn't have to deal with agreements every day. I didn't have to deal with documents every day. It was largely a role of advising senior management, and that seemed very, very exciting. I learned a lot about the business. And once I enjoyed that work, it took over my life for the last 12 years. So I continue to write about the healthcare industry, healthcare issues. It was an exciting time in India as well. There were lots of issues. And there isn't very much writing on healthcare. Right. Academically and professionally. So I found a very nice way of writing, not just op-eds, but also academic articles in journals. And that continues to be what I do these days, is I'm self-funded researcher in healthcare.
That's great, sir. Also, with respect to Cipla, how did being in Cipla shape your perspectives about the industry and specifically with things like generics? And how did Cipla shape your opinions on various things in the industry?
I think everybody who's been at Cipla will say that it changed their lives.
Right.
It's the philosophy of Cipla. It's what they strongly believe in. And that remains irrespective of whether you're still in the organization or not. I didn't have a very long stint there. But the fact that we were able to see how access to healthcare did not exist, what the barriers were for access to healthcare, just an understanding that people deserve universal healthcare. These were ideas that I hadn't thought about before I went to Cipla. Also, I think for a lot of us, we don't engage with these issues because they're not real for us. But everyone in Cipla is very engaged with this issue. So it doesn't matter that you have great drugs. What matters really is, can every patient get it? And therefore, how can we make it happen? If you start from there, that is a life-changing experience for everyone, not just in India, but all over the world. So access to medicines, access to healthcare really took over my life for the last 12 years. So to me, that was the big change. In the past, I thought, okay, there are medicines, there are patients, we buy medicines, we all get cured. We didn't really think, I think a lot of us still don't, think very carefully about, are these affordable? Can we make them affordable? Can we give them access to it? What are the government policies that prevent access to medicines? What are the well-meaning government policies that deny people access to drugs? Those higher level questions, I think I hadn't thought of earlier. And that's been mostly what I think about now. So in that sense, it changed my life. And I'm sure, and I know this from experience of speaking to colleagues, former colleagues at Cipla, that that's a really big thing. Also, the whole world of activism outside what you see in civil society, in the healthcare sector is very specific. They are well researched, they have exceptional capability and expertise in healthcare. So there is really a group of really sharp, intelligent, hardworking activists who do an exceptional job of advocacy in access to healthcare. I hadn't seen that world at all. We see activism on the streets, we see activism politically, we see activism, let's say, for human rights in a sense, but not so much in healthcare. So that world I was not exposed to. And that shook me. And those people have been fighting battles for decades, relentlessly. Many of them get up and do this every day, even when they know that the impact is unlikely to happen anytime soon. Many have gone for decades without being sure that they've had an impact, and yet continue to do it. So seeing those kind of people who are dedicated to this, who live very ordinary lives outside but do extraordinary work, to me that was a revelation.
Right. And I think this experience of yours also takes me to the session that we had in the SpicyIP Summer School, where certain questions that you posed made me think a lot. Even the basic question that you asked about, is patent necessary for innovation, or do we really need IPR? And everything that went back into accessibility and things like that. In the Indian law schools today and in the legal education ecosystem in India, what do you think is missing, which would help students become better lawyers, help them think better, and come out in the industry and think about things like innovation, accessibility? And what is that gap that you feel needs to be filled, or would be good if it is filled?
I think fundamentally Indian legal education is focused on producing lawyers, which means they are trying to, I'm not saying successfully, but they're trying to produce lawyers who can do basic tasks. Unfortunately, if you ask the practitioners, they think that the lawyers that are being produced are incapable of even doing those tasks. So even at that level, the big criticism of law schools and law colleges is that they're not even producing law graduates who are fit to start in the profession successfully. So that's the first criticism. So even that major objective that the law schools have of producing good lawyers, there's a lot of difficulty in accepting that as being accomplished. Elsewhere in the world, we expect that lawyers will ask some very fundamental questions while studying a subject. Maybe we need to go back to that in the law schools here. So in the curricula, the question I asked is there a need for patents to exist? You can only answer that question if you go back and understand why we have a system of patents from a long time ago, how it changed over time, and what it's become today. And we have to ask the question, is that fit for the world we live in today? What's the damage it does to society in the way it's set up? Those are fundamental questions. And I don't think those questions are being asked in law schools. So without understanding the history of patent law, trademark law, or copyright law, why it was good for the time it existed, what has changed, and therefore how do we need to reimagine it? Those are questions that are not being asked. And to me, you can't understand a subject if you don't think of it in this way. If you can't think of it as why it exists today, why it originally came into being, and whether or not it's appropriate every day. If you can't ask those three questions, then you haven't really studied the law very much. Knowing section numbers, knowing the forms, and knowing the rules is not an understanding of the law.
Right.
So that level of understanding, I think, is what is missing. And we saw this in yesterday's session and today's session.
Right.
These are fundamental questions. And they are unable to even give me the answers that are there in textbooks today. So in that sense, I think there is a challenge with legal education being almost like a vocational course. They're able to complete tasks, some would say not well, but at least that's what they're being prepped for. But they're not prepped for asking important questions. They're not prepped for asking questions about the relevance of many of these things in today's world and being able to imagine how it can be relevant, how it can be changed. How do you engage with activists, for example? How do you engage with a different point of view?
Right.
That startles them. Whereas in every other field, it is expected. So in the medical profession, you will always ask, what if? Ask for an opposite viewpoint. What other possibilities exist? That we don't seem to be asking. We're just seeing what is there and accepting what is there.
Right.
That doesn't help with a deep understanding of the subject. And acceptance doesn't help with a deep understanding of the subject. So I think that would be a fundamental change in which law is taught to law students. So understanding what it is, how it came to exist, the impact it has on society. We're not seeing that at all.
Right.
So we're leaving it to the activists to tell us what the impact on society is. And many students will never get access to any of this thinking, the activist thinking. Law schools should encourage more of that. And that comes with the faculty being open to it, the faculty inviting activists, professionals, practitioners, thinkers, jurists to come and engage with the students and encouraging the students to engage with them in an open way. That's the other challenge, that students don't think they need to engage. They think they need to read and reproduce rather than engage the subject. So if we change the way we think of subjects in law school and we think of what we want to equip the students with, then I think they will be more useful to not just their clients, but society generally. The second I find is they are very, very comfortable with words, but not with numbers.
Right.
And to me, that's very worrying, because a lawyer today can't be adequate in the performance of their duties if they don't understand numbers. And law schools just don't focus on data, statistics, data sciences, any of that. I've written a whole syllabus for how to teach data science to law students.
Wow.
But unfortunately, nobody's called me to say, do you want to teach that in law school? And I think in the first year of law school, where they teach you legal method, one of the very important aspects is legal method involves data. So you think you understand very basic terms like beyond reasonable doubt. Well, what is beyond reasonable doubt? 99.9% is beyond reasonable doubt. 75% is beyond reasonable doubt. 68% is preponderance of probability. If you ask statisticians, probability is a number. Is 50% probable? Is 52% probable? Is 53% probable? So we're hanging people on the basis of beyond reasonable doubt. But we are not able to say, does this event occur 73% of the times, or 78% of the times, or 80% of the times? And does it matter? So even the words that we use in the Evidence Act, in the law, we're not able to clearly say what it means. So we all have a subjective, muddled view of what is probable, what is reasonable, without actually seeing the data. Does this event occur every day? Does it occur many times in a day? Is it likely that it could have occurred on that day? We don't ask these questions. So we're working from instinct and personal experience rather than what the law says, which is probability. So even the definition of fact in the Evidence Act is probable and likely. And yet nobody asks the question, what is probable? How do we get to probability? So very basic words that we're using, we are giving them or attributing to them a meaning that is not substantiated by data. So to me, if we get a good foundation, we teach them how to deal with data, and use more data in the analysis, in the arguments, the submissions to court, then you're likely to get more robust results. Those are the two things I think I would hope that law schools take up and change.
Those are great insights, especially when you said that data science and law, that's not something which everybody would think of or not something which we hear of often. And you having designed a course for that, that's really great. And also I think another thing that you said about how things should start from the classroom, I think that is also on the students, right? Like even when the students think and talk, the classroom is the safe space for them to start off anything. So
true, but I think it will only start if the teachers have that attitude.
Right.
So you can't expect the students who just come out of high school to have this awareness. It's really incumbent on the teachers to build this little safe space where these fundamental questions can be asked. They encourage these questions to be asked, present different viewpoints. I find in most law schools, the law teachers are least interested in the law. So if the teachers are not interested in the law, it's very difficult to get students interested in something. So I find even when I go into guest lectures, nobody from the faculty turns up. They may call experts in, very few do, but when they do, the faculty doesn't turn up and want to learn. How often is the faculty engaging in the real world? So in my case, how often are they speaking to people in the pharma sector, in any sector, to understand how does the law work there, so I can teach it better? How can I teach it in a way that is easy for students to understand? If I can relate to something that's happening around me, it's easier for me to understand. So can we make it contextual to what is happening around us? Can we deal with the issues that are in the newspapers and the TV every day? And find how law is in that system. Then students will be able to understand. So if you're teaching access to healthcare, then we should be asking the question in IP, what happened during the pandemic? Why didn't everybody get vaccines? Why did some get vaccines and some not? Has patent anything to do with it? Is it international relationships between nations that has something to do with it? Then you will understand WTO, you will understand TRIPS, you will understand DORA, and then you ask very basic questions. So in a way, if you just have to take the example of the pandemic, take the example of what's happening around us, you should be able to contextualize a lot of this. Then the students will understand, and more importantly, will not forget. If they're just reading sections, they're reading case law, they don't relate to any of that. I mean, kids don't care whether somebody is dying of high blood pressure or diabetes. They don't relate to it. But several of them will have asthmatic friends, family members. So rather than take an example of something that's happened in court a long time ago, this is the question you ask them. And these are the examples that you can give them to relate to trademarks, patents, any of these things, trade secrets, manufacturing, compulsory licenses, the things that are around them, with an inhaler, if they're using them. Some of them may have seen their parents being diabetic. So insulin is an example. So those examples are great. And you can run a whole IP course based on one of these examples.
Real life examples.
Which they are related to each other, to students. So maybe law teachers need to think of how they teach each of these things differently. And we can find products that incorporate many of these features. So you can find a product that has patents, you can find a product that has generics, you can find a product that has trademark issues, has copyright issues. So that requires teachers to invest a little time, make these case studies, and give it out to the students and discuss those in class. They will remember law much more with these examples than memorizing sections or memorizing case law. You can find those much more easily now than you could in our time. So memory may have been useful 30 years ago. Today, understanding insights are more important. You can find information with a click, which we couldn't do then. But we're still using the same pedagogy that we had then, just memorizing it so that we can access information. rather than work on insights and understanding. That would be my recommendation. Can be worked on better pedagogy by teachers interested in the real world, engaging with the real world, rather than teaching it just in a classroom and then going away. There have been instances in the past where I've said that in the United States, law professors file amicus briefs in the Supreme Court on important issues, where they present the court with alternate viewpoints, explain to the court the consequences of this decision. If you decide X, this is what's going to happen. If you decide Y, this is what will happen. Therefore, when the Supreme Court comes out with a decision, it contemplates or looks at future events. Whereas in India, the Supreme Court is no better than a munsif. It just answers the question and decides a dispute. It doesn't think about laying down the law, declaring the law, understanding the consequences of what come out of this declaration of law. So again, law professors, law teachers have a great role to play in creating a future for the law in a way that we understand it better. So those are the roles, if law teachers play, they would be more relevant to the students, and students would be much more prepared to face the challenges in the future, not just looking back on case law.
And that will also help in bridging the gap between what we study in law school when they come into the practice, because I think that is also something which a lot of students struggle with. What they learn in law schools, and then after they graduate, they end up in something which nobody taught them about, or some things even maybe firms don't ask them to do. So I think this would also help in bridging that gap and bringing up students who actually understand the industry in a better way.
Maybe not so much as understanding the industry, but being equipped to ask questions. So they will understand the task better. Maybe they've never done the task before, so you suddenly ask someone to write a trademark opposition. Law school doesn't teach you to write trademark oppositions. That's a specialized skill. But at least they will know what an opposition is. They would have thought of it in class. And you can find examples now on the net, so it's not a big deal like before. You have to memorize what goes in an opposition. You find it once, and then you can learn to do it. But thinking about asking the questions, understanding the fundamental concept is really more important than knowing the rule under which an opposition is filed. So I think students find that they are lost on both fronts. They are not being taught procedural stuff, that is basic skills and to do the tasks in law firms, but they also haven't been taught to think about the question, think about the task. So they are really lost because they have neither of these two skills.
So critical thinking is one of the most important things.
I don't know whether you can call that critical thinking, but it's just the ability to bring to bear the thinking that's been done in class. So we were told that lawyers are different because we think differently. I'm not seeing a lot of that. I find that most people seem to think alike. There's no difference between somebody who's studied law, who hasn't studied law, on several of these issues. Which means that lawyers coming from law schools aren't thinking differently. So even though that is the objective, there is a legal way of thinking, lawyers think differently. We're told all this. We're not really seeing it. So law school is not meeting its own objective.
Right. Thank you, sir. I think these were some great sets of insights. I learned a lot from these, and I'm sure people will also listen to this and get a lot of insights and start thinking about different ways of doing things. Thank you so much for being here today. It was an honor talking to you.
Thank you for having me.